Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Okay, let's go to the Ninth Circuit. Here we're going to go to Stockton, City of Stockton. Yeah. Now, there's a reason I'm doing it in this order. For those who read your blog and then follow us here, I'm going to do this case, and then I'm going to go to the Mobile, Alabama firefighter, because I read a part of the decision, which I'll go through the facts in the Ninth Circuit, I read as governing the process of the suit we're going to discuss in Mobile, Alabama. So, Ninth Circuit, we have a court who upheld the firing of the fire chief. This, you want to see how long court cases last? This is back in 2011, right? So anyone who thinks being part of a lawsuit is no big deal, live with this for 12 years, right? It is. In any event, the court held, and this is important, that the fire chief was fired for legitimate, non-discriminatory reasons, and that's kind of part one. And the court held that the chief who was fired was unable to show that these were pretextual reasons. Remember that when we get to the next case, everybody watching, because that's where I'm seeing the next case is going to go. So we've discussed a million times the McDonnell-Douglas test, which is burden shifting, but ultimately, and they go through it here, right? You have to show, the plaintiff has to show they're a member of a protected class, that they were qualified for their position, that they experienced an adverse employment action, right? So all three of those are pretty easy. And as you always say, it's the fourth prong. That's the focus, where we have to, where the employees got to show, the plaintiffs got to show that other people in a non-protected class or outside their protected class, for example, protected class female, non-protected class male, they have to show that those people were treated more favorably, or that other circumstances surrounding the adverse employment action kind of gave rise to an inference of discrimination. And we'll talk about those here. So on the alternative, a plaintiff can simply show or merely show that they're through either direct evidence, meaning an actual fact I can prove, or circumstantial evidence of discrimination. So here we've got the chief who says that I'm part of a Christian coalition. Now, this is very interesting, right? So I'm not really sure that Christianity is exactly a protected class. I was a little more surprised.
Well, when you make a decision, an employment decision based upon religion,
correct.
You're not, it's not that you're a protected class, but you are the victim of a decision that was based on religion. So.
Now, it's kind of funny, and I'm off topic for a moment, to show that, well, people outside my protected class. Well, when your protected class is the dominant majority, who are we pointing to? Muslims, Jews, you know, it's not, you got to show they're treated differently or better. I always laugh. I'm like, okay, well, if you treat Christians like hell, we can treat Jews and Muslims like hell too. It doesn't matter. I don't know. Can I say hell on YouTube? Who knows? So, but here there were comments of opinions about the chief who's a member of a Christian group. And they said these mere comments, the court said, that doesn't constitute a discriminative animosity. That simply because there was comments by people that he's part of a Christian mission, and that this mission is a church clique, did not rise to the level of discrimination needed to prove it. I'm not suggesting that people should then go out and make comments of a derogatory nature about people's religion or the groups they belong to, right? For example, one might believe, and you could say, oh, Muslims are all terrorists. Oh, I'm not making a comment about you. I'm just talking about Muslims in general, right? That is not how you should read this decision. It's just that these pejorative negative phrases wasn't instructive, or wasn't evidence of the person making their statement's own bias. And that was the key. He wasn't saying, I think the Christian clique is bad. He's just making a general reference about other person's perceptions. And that's key here. If the fire chief gets up and says, oh, all Christians are crazy, or all Muslims are terrorists, or all Jews are greedy, you know, whatever you want to say, that's different because he's reflecting their own bias. And then the decisions you make pursuant to your bias are going to be tainted. That's not what the court found happened here. The court found here that they were talking about this person making comment was talking about other people's biases, which, you know, I hate to think of this and I hate to say it this way, but Trump was just, as much as people like or hate him, probably the latter, Trump was just talking about Governor Christie. And as he's in the audience, he turned to somebody and said, oh, don't say he's a fat, overweight, whatever. That you shouldn't say that he's fat and overweight. That's mean. I would never say he's fat and overweight. You're saying he's fat and overweight. You shouldn't say that. I would never say that, right? So that's not what we're talking about here, but that's what it brought to mind that anyway.
Well,
so
I think the issue, the fundamental issue here is that the chief was doing taking some religious liberties while he was supposed to be working. All right. He brought some religion into the workplace. He went on a religious leadership, went to a religious leadership conference on taxpayer time, and I'm not sure at taxpayer expense, but certainly on taxpayer time. And there were some allegations that he was playing favorites based on religion. So I think it's really hard to tease out religion from this the decision making here. And I think that the court spent a lot of time talking about that, but that the religious decision making, like for example, if he had gone to a different denominational conference, it still would have been the same issue. It wasn't because he went to a Christian event. It was the fact that he went to a religious of any denomination event at taxpayer expense that didn't really have a benefit to the taxpayers. And some of the other decisions as well.
Yeah, and the court makes, and this is because it's going to be my transition now over to Mobile. The court makes point to say they couldn't prove that the reason they actually fired him was a pretext for the real reason, which was their discriminatory animosity, hatred, whatever. Pretext